Good afternoon. This is Sripriya Kumar here, and I am the chairperson of the Corporate Laws and the Corporate Governance Committee of the Institute of Chartered Accountants of India. On behalf of myself and my Vice Chairman, Sri Durgesh Kabraji, I'd like to extend a very, very warm and a very hearty welcome to all of you to this webinar on Section 90 of the Companies Act 2013 on this concept of significant beneficial ownership. I'd just like to set the context in terms of a very short preamble, as well as an introduction of the speaker of the day. I also take this opportunity to extend a very warm and a very hearty welcome to a very young and a very dynamic company secretary whom I've had the pleasure of knowing. His name is C.S. Prakul Thadi. So welcome, Prakul, and Prakul's here to walk us through this provisions of Section 90. And this is an initiative of the Institute of Chartered Accountants of India, primarily, sort of on request from the Ministry of Company Affairs, the Ministry of Corporate Affairs, where they wanted us to actually do a series of webinars to popularize and to ensure compliance with Section 90 of the Companies Act 2013. So the basic intent of Section 90 of the Companies Act is to find out the true owner of a corporation. This whole process has sort of gotten very complex with the emergence of artificial legal entities. So what happens? There are corporates which are held by corporates, which are held by corporates in terms of shareholders. And one genuinely does not understand who is the true owner of the corporation. And it's in that context. And today what happens? Everything that can go wrong with a legal vehicle in not determining an ownership can go wrong in terms of there could be, money laundering, there could be terrorist financing, there could be a whole lot of actions which are not quite right for the world. A whole lot of economically or commercially connected actions that could not, terror financing for one. So there is a global mandate to do this, and there is something called as the FATF, the Financial Action Task Force, that says all countries have an obligation to identify the true owners of the corporation, because these legal vehicles which don't have a name and a face could be used for other purposes. And there is a global move to identify natural persons is born out of a realization that artificial legal entities can continue to proliferate. And while these are continued to be owned, ultimately the owner of anything has to be an individual, right? Because he has to put in the money in a company, and that company can downstream into further companies. But it's to identify that individual who's possibly controlling entities, and some of these entities could be into illegal activities. So it's that need that actually defined the need for an SBO provision in the Companies Act 2013. With that, I also take an opportunity to introduce Prakul. Prakul is an insolvency professional and a practicing company secretary. He's also a lawyer and a cost accountant. And he's worked in corporates before the commencement of his private practice. He's finished his internship at large firms in the insolvency space, and he's also assisted in the in insolvency processes of several large corporates. And more than anything else, I found Prakul to be extremely articulate, very easy in terms of explaining a provision of a law and backing it up with facts which are relevant to a situation. So may I please kindly request you all to virtually put your hands together for Prakul, and it's over to him. Thank you, Prakul. Thanks for being here today.
Thank you so much, ma'am. That's such a warm welcoming I have got. So can I kickstart into the presentation directly, ma'am? Yeah. Just a second. I'm just sharing my screen. Yeah. Today's presentation, or rather the topic for us, is on sensitizing these provisions on Section 90 of the Companies Act 2013, which pertain to significant beneficial owner. Now, before we go in detail on the significant beneficial owner, I think the introduction provided by Sripriya ma'am is extremely helpful, which I would love to repeat for the simple reason that sets the context in which we are trying to interpret these provisions and in which we are trying to advise our clientele on applicability of these provisions. So before I go to Section 90, let us spend a minute on Section 89. So Section 89 is a straightforward section which talks about two important disclosures. One, who is the registered member? Two, who is the beneficial owner? Now, what is Section 89 talking about is that, like, for example, let's say there is a trust. And as we all are aware, a trust cannot hold shares in any company. So it is a trustee who holds shares in a particular company. That's number one. Let's take another example. Let's say you are incorporating a wholly owned subsidiary. As per the Companies Act, you need at least 2 shareholders if the company is a private company. You need at least 7 shareholders if the company is a public company, public limited company. So depending upon the type of company, you will bring in certain nominees as shareholders holding 1 share each, right? So that is for on the sole purpose of meeting the minimum number of shares. But there is absolutely no voting interest or anything. Of course, on books they do have, but ultimately it is by the major holder of the shares. So in these 2 examples, what effects essentially happened is, in the first example, though the trustee is the registered owner, but it is the beneficial owner is that of the trust. Similarly, in the second example, though the nominee shareholders are the registered owners, the beneficial ownership is with the company which had the 99.99% of the holding, or the individual who has the 99.99% of holding, and for whom these shareholders are nominees. So Section 89 was only tackling with a simple point that in my company, in my shareholders, are they the registered members alone and not the beneficial members? Then give me the details of the beneficial members also. There are 3 forms, MGT4, MGT5 and MGT6, wherein in MGT4 and 5, the registered owner and the beneficial owner will give the disclosure. And in MGT6, the company will file such disclosure with the ROC. So it is straightforward. There is absolutely no interpretation issue. It's completely plain because they are my shareholders and I also have certain level of knowledge on the shareholders. Now, taking this a step forward under Section 90, and also as Sripriya ma'am rightly highlighted, globally, there was an initiative to tackle shell companies, to tackle and also to identify the actual source or the actual person who is responsible for all these companies or the operations. So as we all are aware, though the company is an artificial person, it is always backed by a natural person, right? So the very intent of the Section 90 is to identify such natural person, and in a process or in a methodology to identify such individual, these provisions have come, not just in India, but this is a byproduct. Rather, I would say there have been number of such actions which have been taken under FATF, the Financial Action Task Force, including even when you open a bank account, as simple as opening a bank account, there is a FATFA declaration. Any banker will give the declaration to you to sign when you are a company, where you will have to disclose who are the beneficial owners. And today, as we speak, the shareholding patterns we file with stock exchanges, we are disclosing who are the beneficial owners to the extent available with us. So ultimately, what went as a global phenomenon was that where there is a single shareholder or where there is any number of individuals who are managing or controlling a company, though it is not prohibited, at least it is important that we know who is that individual who is having a significant interest over the company, right? So these provisions firstly are not prohibiting anything. They are not prohibiting you from being that individual to have a significant interest. The only intent of this is the regulator has to know who is that individual who is having a significant interest over the company. That is what is the context of these provisions. So we are looking for individuals. Now there may be a question. Let's say I am a company. Only individuals are the shareholders in this company. Does that mean they are significant beneficial owners? The answer is no. The significant beneficial owner provisions talk particularly about indirect holdings together with their direct holdings, if any. But the ultimate idea is with respect to indirect holding through any other person. That is through a corporate, body corporate, through partnership firms, through trusts, through pooled investment funds. So there are certain vehicles through which you are investing in a company, but your name is not directly reflected as shareholder in that company, right? In such a scenario, how do you go back and trace who is that individual who is responsible for this, or who is the one who's having a significant interest over this company, is what this whole concept of significant beneficial ownership is all about. So the first phenomenon which we have to keep in mind, or first thumb rule we have to keep in mind, is this significant beneficial ownership is not about direct holdings alone. It is about indirect holdings plus if there are any direct holdings in a company. So if a company has only individual shareholders, they cannot be, this section 90 will not be applicable, in the sense that there is no reporting which mechanism for such companies where you have only individual persons in the shareholding, right? So that is what is the basic context we need to understand before we jump into understanding who is a significant beneficial owner. So with this brief idea, let us now jump into understanding section 90, wherein I've extracted a brief provision of it. And I would suggest in this session, my intention is to run through the BEAR Act to understand each and every provision and then come back and see the practical applicability of it. But before that, the major thing is to understand who is a significant beneficial owner. So let's try to understand that using section 90. So section 90 states as above, as you can see on the screen, it says every individual. So let's pause there. Now, every individual is what it is trying to highlight, right? So this every individual is something which we have to remember. So this every individual is something which is the crux of this particular provision. So it is not talking about a corporate or or partnership firms. It's talking about particularly individual. So a beneficial owner shall essentially be an individual. So every individual who acting alone or together or through one or more persons or trust, including a trust. Now, the second part of this definition, or rather the explanation, is acting alone or together. Now, over here, there are certain practical issues which will crop, which I'll get back to you at a particular point in time during the presentation. But the idea is you may hold it together with somebody as well, or through one or more persons. Now, through one or more persons, what does that mean? That means it need not necessarily be that you are at the immediate next step. It may be such that you are holding shares in a company which holds shares in another company, and that company holds significant interest in some other company, and that company holds interest in another company. And I'm talking about foreign companies because we have a 2-company layer restriction under the Companies Act 2013. But here you may be a holder of shares in a foreign entity which has 3-4 subsidiaries, and the 4th subsidiary has investment in the Indian company. So through one or more persons also you can still have the significant beneficial ownership. We'll get to that. Or trust. Now, even as a trust, as I said, there's a trustee, or through different trusts you are investing this, and ultimately you are the one who created a particular trust. So that can also come here, and including a trust and persons resident outside India as well. So an individual can be a person resident outside India as well, who holds beneficial interests of not less than 25% or such other percentage as may be prescribed. Now, this is something which we have to remember. Now, the section says 25%, right? Now, 25% is actually a very big number. Like holding 25% in a company is as good as you are controlling certain special resolutions, and you're having much better control and interest over an entity, right? Now, it doesn't stop there. It says, or such other percentage as may be prescribed by the MCA. Now, if MCA comes in its rules with such other percentage, then such other percentage shall prevail, right? Now, it doesn't say whichever is higher or whichever is lower. So, and under this rules, the MCA had actually prescribed for 10%, as you can see in the second point. But that the enabling power of MCA has come from this section 90. So, there should not be a misconception that 25% is the finality. The concept is that what percentage the MCA has come out with, that will have a bearing. So how we have to read this is that MCA will have the discretion to come with a particular percentage which decides whether you are a significant beneficial owner in that company or not. Right? So 25% should not be treated as the criteria. You are supposed to get back to the rules and understand what is the percentage. If the rules are amended or updated, then such updated percentage will have a bearing. So in this explanation provided under section 90, the reference to 25% shall not be considered as final. Right? Now, so I repeat the explanation. Every individual, either acting alone or together, through one or more persons or trust, including a trust, and persons resident outside India, holds beneficial interests of not less than 25% or such other percentage as may be prescribed. Now, where is it? In shares of a company. If they have such beneficial interest in the shares of any company, or the right to exercise, or the actual exercising of significant influence. So the second is if you are able to exercise significant influence or control. Now, exercising significant influence is one thing, or you're exercising control as defined in section 2, subsection 27. So there are three criteria. One, you are holding shares. Second, you're able to exercise or actually exercising significant interest on the company. So even if you have a right to exercise a significant interest, that is enough. You influence, that is enough. You need not, there is no mandate that such exercising, you need to actually exercise a significant influence. So even if you have a right to exercise significant influence, that is also one of the criteria. Or the actual exercising of significant influence is one. Or you have a right to exercise control, or you're actually exercising control. And the control is defined under section 2, subsection 27. Right? And when this happens, you as an individual will become a significant beneficial owner. Now, this read with the rules. Let's try to understand from the rules what is a significant beneficial owner. Who is a significant beneficial owner? Now, as per the rules, where again it says an individual either acting alone or together or through one or more persons or trust possesses one or more of the following rights or entitlements in such reporting company. Now, it says rights or entitlements. Now, what is this right or entitlement? We'll get to that. But there are certain straightforward criteria. First, let us try to understand that. Number one, holds indirectly. Now, see the language, how it is worded. Indirectly or together with any direct holdings. So, indirect holding is a must. As I've explained at the beginning of the session, if you're an individual and you're having direct shareholding in a company, there is no applicability of these rules. There is no, you're not sitting and explaining or kind of elaborating on whether you are a significant beneficial owner over this company or not. No, there is no interpretation happening on that ground at all. But there is a company in which another entity is having shares, and you are having certain interest in such entity, not directly in this reporting company. So from here on, I will refer to the company as reporting company. So the company in which you as an individual are having a significant beneficial ownership will now be referred as a reporting company. And you are not the shareholder of this company. You may or may not. But ultimately, I am not sitting and looking at your direct shareholding in the company. I am looking at and I am actually trying to explain your indirect shareholding in the company. That's when you will become a significant beneficial owner. If you don't have any indirect holding and you only have direct holding, you will not come within the ambit of significant beneficial ownership. So this I would like to conclude in clarity. Now, as I move forward with the definition, holds indirectly, right, or together with any direct holdings. If you have direct holdings, then you club it along with my indirect holdings. And that is not less than 10% of the shares. Now, over here, I would like to just take a second to explain one key concept. Now, let's say there is a company A, right? And there is a company B. Now let's assume A Limited and B Limited have a interest. Okay. And I'm taking a very simple example here. Let's say S is the shareholder in A Limited. let's now provide the percentages also to make the example more interesting, right? Now let's focus on these detailings. Now let's say S has 80% stake in A Limited and A has 30% stake in B Limited. Now let's take this as one example. Now let's keep the facts same. And the second illustration, let us try to come with another interesting thing. Let's say S here has only 30%, while in B Limited, A has 80%. I just reverse the numbers. Now let's go with the first example, where S is the individual. Now this clarity, let me give you this. S is the individual who has that 80% stake. Okay. So S is the individual. Now in our example, B Limited will be the reporting company, right? This also let me clarify for the sake of our understanding, right? Now B Limited is the reporting company. Now where S is the individual and B Limited is the reporting company, what I'll have to see as a consultant, what am I looking at here? I'm looking at whether B Limited should make a disclosure that, or rather, whether first step is whether this individual should make any disclosure to the company saying that, boss, I am a beneficial owner of your company, and whether reporting as a reporting company should I look into this particular situation and tell S that why are you not disclosing this? No, I mean, of course, the procedural aspects I'll come immediately after the explaining the significant beneficial owner, the definition. But in this example, if you understand this example, A Limited is only controlling 30%, both voting rates as well as shareholding in B Limited. Okay. Now I am having 80% in A Limited. Now, what is my effective control over B Limited? If this is my question, there can be two possible answers to this. The first answer will be straightforward. I have 80% in A Limited, so I can control 80% of the decision making in A Limited. Now, A Limited has 30% in B Limited, which means 80% of 30, which is 24% is what will be my effective control in B Limited, which is indirectly, right? Now, that's the usage of these words, holds indirectly, not less than 10% of the shares. Now, in this example, I'm holding more than 10% indirectly. 80% of 30 becomes 24%, and I still hold more than 10. So I should be in a position, I am a significant beneficial owner in this company, is one set of interpretation. Now, again, just to highlight, the percentage is 10, not 25 as per the section. Section says as may be prescribed by, as may be such as the percentage as may be prescribed, and the percentage as may be prescribed was 10%. Now, coming back to this example, since S has 80%, here we made a clear calculation of 80% of 30, which comes to 24. Now, I said there are two possible interpretations. What is the second interpretation? Now, if you take this interpretation a bit forward, S is having 80% in A, which effectively means S can control almost any decision making in A, right? Because under the Companies Act, any decision making is of the shareholder is with respect to 75% of shares. Like it's a special resolution. If you're holding 80, it indirectly means you have ultimate decision making power in the company. Now, again, this is an interpretation to provide for. Now, when I have this interpretation, it effectively means whatever A Limited holds in B, I effectually hold the same percentage of control in B. So my second possible interpretation and the answer will be S holding 30% of indirect stake in B. Now, this is quite controversial interpretation to make. It's because 80% of 30 is equal to 24 is mathematically correct and it can be justified also. But my second interpretation as to where I say, as an individual, I hold 80% in a company, which means I effectively control the entire company's decision making in terms of my dividends or in terms of anything you take to the shareholders. If I vote by 80%, it is approved. That is the kind of power I hold by virtue of me holding anything above 75%, right? So which does this mean I am indirectly holding 30% of stake in B Limited because A Limited is ultimately controlled by me without any exceptions? Is that what, can I do that interpretation or can I not? if you ask me, can I would definitely say yes, you can. If by virtue of every possible interpretation, you can prove that S, since it has more than 80 percentage, or since she has more than 80 percentage in A Limited, such an individual will effectively have control of the entire company. So, which means effectively she has 30% control of B Limited is also a very sensible interpretation to make. But to keep things simple, it is definitely advisable for you to do a direct calculation of 80% of 30, which comes to 24% of control in B Limited to compute the significant beneficial ownership. However, to keep the intent over, or the spirit over the form, that is to have the intent there, the intent is, what is it that the significant interest you have on this company? What kind of control you can have on this company? When you go with the intent, the answer should be you have insignificant interest of 30% over B Limited, because though you only have 80% in A, you are able to essentially control the entire company's decision making in A Limited. So you have an essential control over A Limited to a complete tune. So, and hence you need to you can compute this as 80% of 30, which amounts to 24%, and which is which should ideally be valid. I'm sorry, 80%, like 100% of 30. Sorry, in the second example, it will be complete 100%. That is 30% of control is what you have, is how you can interpret this. And similarly, if I take this interpretation much further, if I want to make this example much interesting, let's say I have 51% of stake. Now, even 51 is a significant shareholding in a direct shareholding in a company. So with 51%, if you can still control a majority of decision making in the company. So there is another round of argument where, again, this is I'm talking purely from the practical point of view, where we have witnessed certain cases where such kind of instances have happened, and there are multiple interpretations taken by multiple professionals for the reason that there is no clarity in terms of this calculation of the percentage. The calculation of percentage is left completely on beneficial owner to provide for. So in such a situation, the safest thing is to definitely be safer to say that, yes, as a shareholder, I have more than 51% in a company, which effectively means I have a significant interest over this company. So I will treat it as 100% for the computation of my indirect holding in B Limited. Because if I take 50%, 51% here, it would come to 15.5% of indirect interest in B Limited. But essentially, you are having a complete control over B Limited, because A Limited cannot take any decision in B Limited unless you have an ordinary resolution in place. So this is a debatable thing. But as I say, the safest thing would be to always go with the intent of the law and try to come open and try to make such liberal interpretation as may be possible, to see to it that in any given scenario, no regulator gets back to you to question your intent of investment in these companies, because it is only a disclosure. There is no prohibition. However, the other interpretation also is equally justifiable. You can still justify any of the regulator to say that I have computed a percentage over a percentage. So I hold 51% in A holds 30% in B. So essentially I hold 51% of this 30% in B. That is also a sensible remark to make. But let me give one example. Let's say B Limited is taking a decision in an EGM. Now B Limited needs voting from A Limited. Now A Limited votes to the tune of 30%. Correct? Now, A Limited's decision making, how far is it influenced by the individual S, is something of paramount importance for us to understand if yes is actually having an impact of seeing that his vote is kind of deciding the ultimate vote of A Limited, or does S vote is only proportionately deciding the ultimate decision of A Limited. Now, this is the concept. Once we understand, we will get a sense why I'm talking about the second interpretation, that is of A Limited. Yes, having a control over A in such a way that any decision of A in B is not decided by any other individual holders of A Limited. It is purely decided at the instance of S. If S says yes, it is yes by A Limited because of the majority stake which S holds. If S says no, then A Limited accordingly says no even in the decision making of B Limited. So this is indirectly giving me a sense that whether S has a ultimate control over A In such a situation, then you treat that S holding in A as 100% to compute the indirect holding in B. But if S is, that is the individual's decision making in A in this example is proportionate. For example, let's say here they only hold 40%. Now, in this case, when even through my 40%, I can only influence to some extent. I cannot influence a complete decision making of A because the other 60% holders can actually decide otherwise. And therefore, I am indirectly holding only 40% of my decision making in A. So this 40% of 30% will become 12. So I do have a significant beneficial interest in B, but by virtue of computing this 40 into 30%, right? But in my previous examples, as I was explaining, it was very clear. Like 80% is like I either say yes, which means A limited does this to B. If I say no, A limited does not do this to B. So it indirectly means I'm holding 100% in A. It's an indirect holding when I'm computing. As a matter of practice, I should voluntarily express that since I have more than 50% control in the company, the decision making of A limited with respect to B limited is always my decision what is going to prevail over this, anything we do over B. Even if I want to sell off the shares, or even if I want to control the shares, make any proposal in B limited, for every of that, my shareholding of more than 50% is deciding this. So in such a situation, I would consider the entire holding of A in B as my indirect holding. That is what is expected from these rules. But if you go strictly in the literal, you go with the strict interpretation of what is provided for indirect holding, then yes, 80% of 30, which is 24, comes 24% of indirect interest in B is also can be justified. I hope you understand this differentiation I'm trying to make. Now let us take the other example we have here. So again here, S is the individual, A limited is the company. We just have to change this figures. Right? Now when you look at this example, you may have a feeling that S does not have more than 50% in A. So there is no point of even looking at the calculation because there is no significant ownership in A per se. And the answer is wrong. Even if you have 10% here, let's take a simplest example. Let's say you only have 10% in A, but A has 80% in B. Now, with 10%, you can't decide what A has to do with respect to the decision making in B. But you still have to make a calculation and see if the indirect holding is exceeding 10%. And over here, the indirect holding is coming to 10% of 80, which is 8%, which is less than 10%. So in this example, S being an individual is not a significant beneficial owner in B limited. Let's take another example. Let's take 12%. Now 12% of 8 is coming to 9.6, right? So 9.6 is also lesser than 10%, so it's not viable. Let's take 20. So 20% of 80 is 16%. It is in excess of 10. So S being an individual who is holding only 20% in A will still be treated as a significant beneficial owner for the purposes of his indirect or her indirect holding in B limited, which is 20% of 80 coming to 16%, which is in excess of 10% as stipulated by the MCA. So this is what is expected to be disclosed in BEN 1, which is a beneficial disclosure form, which I will run you through, the form I'll run you through. And it is also expected for an individual holding shares in a company to understand. Like, for example, our client is an individual and they have shareholding in various companies. Now, suppose we are advising the client on this BEN forms or this significant beneficial ownership. The step one we'll have to see is, okay, what are all the corporate holdings our our client has as an individual? I'm talking about individual client. What all corporate holdings they have? And in each corporate holding, we need to understand, does these corporate holdings, do they have further investments? Number one. Number two, if they have further investments, are they subsidiaries are they subsidiaries of this company? Now, if they are subsidiaries of this company, then you have to again further go on to the other company to see what, to understand what kind of percentage this company has in that, because subsidies is very clearly disclosed in your consolidated financial statement. So it's easier for us. But if my investee company, that is, I invested in a particular company, and if that company has further invested in multiple companies, then for me to understand from the balance sheet of my direct investee company, I can see what are other companies where it has got investments. Now, Accordingly, I'll have to make an individual calculation that my percentage in this company is 20% and this company is holding in multiple companies in a different fashion. So now what is it that I am going to invest? I mean, what is my significant interest in such other company? Now, does that stop there? No. And what if that other company has further investments? Right. So let me just try to let's show that in by way of this example. As I said, S has a shareholding in A is in B. Now, let's say B is not the ultimate reporting company. Though, of course, B will also be one of the reporting companies. Let us try to complicate this by adding more companies into this. Okay. Now, let's try to add more companies into this. Now, we have made it 4 layers, right? And in this layer, let me lay out few other companies as well. Okay. I'm just trying to take in a complex situation just to make sure that we have all sets of information with us. Okay. Now, if you observe this company, now if you see, as an individual, you have 20%. Let's make these numbers also big for the time being so that there is a possibility for us to gather what we are trying to do here. Now, let's say A Limited has 100% in B. B Limited has 2 subsidiaries. Okay. Now, let's say this A is an LLC. It's a foreign company. Okay, let's assume it's a foreign company and which has a holding in another foreign company. And this foreign company is having subsidiaries in India. Okay. Now let's say it has all 100% owned subsidiaries. I'm trying to just make this example simpler because there are too many layers. And then ultimately here in this company, we have C Limited has 80%. Okay. Now, if you see this example, yeah. So if you see this example, first and foremost, we will have to come from this company. There are 2 points of view from this. One, the point of view should be from the company's end. The second point of view will be from the individual's end. So since we are discussing from the individual's point of view, assuming individual is our client, let us see how it comes. Let's say we have an individual who is our client, who let's say is a foreign national, Indian, whatever. Now they have an investment in a foreign company. And that company has further investment in another company. And that other company has further 3, investments in 3 subsidiaries in India. And of which one of the subsidiary has got another investment in another company. Now, this is the complete structure. So, in this D Limited, because now to whom all is this reporting applicable? The reporting is applicable to these companies which are incorporated in India. That is for, let me just change the name so that it's more easier. Yeah. So, in the disclosure requirement or the reporting requirement is applicable for C, D, and E, and also for F, because these are incorporated in India. Now, from the individual's point of view, just try to imagine what level these individuals have to go to determine if they have significant beneficial ownership in any company. There may be various challenges. Maybe I'm just giving you a simple example. What if A has, in this, these are these layers. What if, similar layers are there for A? Right? Even that is a challenge, correct? So what if A also has got similar layers? And what if this percentages are not 100%, they are 10%, 3%, 10, 8%, 7% in various cases. Now, how do you actually run through and understand if you have that significant beneficial ownership or not? We'll come to that. But before that, let's try to dig this case. Let's say our client is an individual. They have a holding in a foreign company. So first and foremost, we should understand in that foreign LLC, what are the further investments? Let's say there are no other investments, but it has one subsidiary, which is BLLC. Then we will have to jump to BLLC to understand what all investment does BLLC has. Now, BLLC has further 3 subsidiaries incorporated in India. So which means in these 3 subsidiaries, in all these 3 subsidiaries, as an individual, I have a significant beneficial ownership because 65% I have in A, And that is in 100%. Now, I'm not taking the second interpretation I made. We will go with a simple mathematical interpretation. So 65% of 100% is again 65%. So indirectly, I have 65% control in BLLC. Now, BLLC has 100% in C, 100% in D, and 100% in E, which indirectly means I have 65% control in C, D, and E. Now, as an individual, for this C, D, and E, I'll have to disclose by way of filing form Ben 1. So form Ben 1 is the form which I'll have to file for individual. I mean, when I know that I have a significant beneficial ownership in a particular company, I'll have to file form Ben 1. So filed by S, right? Filed by S, that is individual. And in where all do they file? Does S file this? So S files this with C Limited, D Limited, E Limited, and F Limited. Now, these are all the companies for which S will have to do the disclosure. So S has to disclose to C, to D, to E that I have 65% of indirect control over your company. And now going a layer further, this D has 80% in F. So which essentially means there is a 65% of 80, right? So 52% of stake is what S indirectly has in F, and the same has to be disclosed by way of filing form Ben 1 with F Limited. So this is from the individual's point of view as to what all disclosures have to go from the individual to from the individual into the reporting company. So in our example, S is the individual and we have 4 reporting companies, C, D, E, and F. But there is one exception. The exception is with respect to D and F. Now we have a very clear understanding here that D is a holding company of F. So where there is a holding company of the reporting company, then if the reporting company does the disclosure and the reporting company also discloses its holding company's details in its disclosure in form Ben 2 with the ROC, in such a situation, the holding company that is delimited in this example is exempted from making a further disclosure with the ROC, right? Now I'll repeat this explanation, but before that, let me give you that procedure clearly here. Right? Now, as I said, form Ben 1. Okay. Now, form Ben 1 is filed by whom to whom? It is filed by the individual to the reporting company, right? So this is something which is important. So form Ben 1 is filed by an individual to a reporting company. Right? So it is by an individual to a reporting company. Now, the second stage is when after the individual after there is a filing of this form with the reporting company, what should the reporting company do? The reporting company will file this with ROC, and the form used for this is form Ben 2. Now this is what is the rule position. Okay, so there is a so let's try to understand this flow, which is very much important. Whenever an individual realizes that there is a significant beneficial ownership as explained by us, then the individual shall file a form Ben 1 with the reporting company. And subsequently, the reporting company shall file form Ben 2 with the ROC. Now, what is there in Ben 1 and what is there in Ben 2 is something which we'll do immediately after understanding the complete definition of significant beneficial ownership. But what is furthermore more important is for us to understand this process flow. So the first disclosure always comes from the individual to the reporting company, and only after it is reported to the individual to the reporting company that the reporting company can file a disclosure with the ROC. So I was explaining you the complete interpretation from the point of view of the individual. Now let us think from the point of view of the company. Let us say our client is the company, not the individual in this case. Now in this example, let's say F Limited is our client. Okay. Now, when F Limited is our client, what do we do? First and foremost, we will have to look back and understand the shareholding pattern of F Limited. We are not now looking at the investments of F Limited. Let us assume F Limited has no investments as such. Now we'll have to dig back into understanding what is the shareholding pattern of F Limited. Now, as we go back and understand what is the shareholding pattern of F Limited, we will see that there is one company, T, which is the holding company in F Limited. It has 80% of stake in F Limited, which is good. Now, after we understand that there is a subsidiary relationship, now we'll have to ask for the books of D Limited to see whether D Limited has any further back, downstream, like what upstream I'm going back to understand the shareholding pattern of D Limited. Whether in D Limited shareholders, are there any individuals? Because in F Limited shareholders, if there are any individuals, they are out of the ambit of the significant beneficial ownership. But when F Limited has D, and if D Limited has further shareholders in, the shareholding pattern of B LLC, or rather, in my holding company, that is D Limited, if there are other shareholders who are individuals, then I'll have a question mark whether they are significant beneficial owners or not. In this example, the shareholder of D is a single shareholder, which is B LLC. So, which means at the level of D, I don't find any other individuals who are having significant beneficial ownership over F Limited. Now I'll have to dig a step further. Now I'll have to obtain the books of B LLC, the shareholding pattern of B LLC, or the partnership interest in B LLC. Then there I would see that there is only one single shareholder or partnership single shareholder in B LLC, which is A LLC. Which means again in B LLC, I have ruled out that there is no possibility for me to have a significant beneficial owner, because a significant beneficial owner shall be an individual, right? So since in B LLC also there are no individual shareholders, I have no other option but to dig back and to go to A and to understand in A's shareholding pattern, is there any individual? So there I realized that there are two shareholders in A LLC, one individual of 65% and one corporate of having 35%. Now, because in A there is a corporate of 35, again I'll have to dig back in the 35%. Is there any other individual? Because 35% of 80 is again paramounting to more than 20, more than 10, which means there can be an individual. There can be another further individual in that entity. So it's going on, right? No, but since we want to stop it here, let's say there are two individuals. S1 is one individual holding 65% in A Limited, in A LLC. Similarly, let us take one more entity, S2, right? Now, let's say S2 is another individual who holds 35% in A LLC. Okay. Yeah. So, since S1 and S2 together hold 100% in A LLC, now what effectively happened here? Right? Just to keep things clear. Sorry for the pause. Just wanted to keep this table clear. And I wanted to do this table alongside so that there is a better clarity. Yeah. So now if you see this, in ALLC, we have two individuals now, right? So I have come down as a client, as a professional advising F Limited. I started looking at the shareholding of D, couldn't find an individual there. Let's say, this in F Limited, I have one corporate and rest 20% is held by an individual, assuming. So I have seen shareholding of D. And in D, again, since D is held by one single shareholder corporate, I could not find the individual member. So I had to look at the shareholding pattern of B LLC, in which again there is only one member, again a corporate, A LLC. So again I had to look at the shareholding pattern of A LLC, and in A LLC I've got two members, both of them individuals having 65 and 35. Right now, as a company, I have went back and gone to see this. Let us say I have realized that S1 and S2 are significant beneficial owners through my interpretation and through the documents made available to me, or the two documents I could gather and do this investigation. I did this. Now, does it give me a responsibility to directly disclose this with the ROC? The answer is no. And kindly mark this. This is very important, and this can be one mistake we can unnecessarily advise to our clients. Right now, in an instance where, as a company, as a reporting company, I know that there is an individual who is a beneficial owner, and if that beneficial owner has not filed the disclosure in Ben 1 with me, I don't have any responsibility to file Ben 2 with the ROC. I don't have a responsibility to inform ROC, but I have another responsibility to do, which I'll try to capture in some time, right? So this other responsibility which I have is nothing but informing or sending a notice of beneficial interest to that respective individual in form Ben 4. And there is a set of procedure as to how I'll have to tackle it with in line with NCLT. I'll explain you that very briefly during the session. But that is purely from the point of view of how the company has to look into it. But my crux of identifying this and trying to explain my takeaway from this discussion is that as a company, I can never file Form Ben 2 directly with ROC without a Form Ben 1 disclosed by a significant beneficial owner individual to me as a reporting entity. So unless a disclosure of beneficial interest, beneficial ownership by a significant beneficial owner individual in Form Ben 1 is made with the reporting company cannot make any disclosure with the ROC. That's the thumb rule. Right? So with this thumb rule, now let's try to take things much forward. In this example, if you see, and going back to the example, I have found that in F Limited, S1 as an individual of 65% has indirectly 52% in F Limited. Similarly, S2 with 35% of stake has an indirect holding of 28% in F Limited, which means both S1 and S2 being individuals, they have significant beneficial ownership in F Limited. So they will come within the definition of significant beneficial owners, and they have a responsibility to file Form Ben 1 with all these reporting entities. Now, coming to Ben 2, the exception part of the holding company is that in this example, since F Limited is filing as a reporting company to the ROC in Form Ben 2, in Ben 2 itself, there is an option to give the disclosure of details of the holding company, holding reporting company. So in this example, D Limited is the holding reporting company. So in an instance where the reporting company, that is F Limited, is disclosing the details of D Limited, which is the reporting holding company, then this responsibility of disclosure of Ben 2 does not apply on D Limited. That is something which is an interesting thing. So if you have a client who has a subsidiary, and the subsidiary is doing this disclosure of Ben 2 and also disclosing your details as a reporting holding company, then your client, that is D Limited in this example, does not have any obligation to file Ben 2. And this will not apply on your client, that is D Limited in this example. So this is the basic idea and concept of significant beneficial ownership. If you are able to follow the channel which I was trying to route through, and if you're able to follow my example, you are 100%, you will be in a position to understand the significance of this definition, and you will also be in a position to understand the complexities which can come up in practical scenarios. I'll also, before the session, try to give some complex situations which we have faced. But ultimately, I feel, in this session, I'm more trying to focus on the academics, to focus on giving a clear understanding of what the law is. Probably if the institute allows, maybe in one other session, we can focus purely on the practicalities and also certain, various scenarios which we can take to better understand the practical nuances in significant beneficial ownership. Now let's run back to our definition. So in our definition, we were only at the first part, wherein we are focusing on holding indirectly or together with any direct holdings not less than 10% of the shares. In such a situation, you will be a significant beneficial owner. The second level of step is holding indirectly or together with any direct holdings not less than 10% of the voting rights. Now, if you ask me, Prakul, is there a situation where I don't have shares, but I have voting rights? Is it possible? Absolutely possible. And we have seen this even in the definition of related party. We have seen this in, independence of an independent director. Everywhere, this is quite common. That even without you holding shares, you can still control the voting rights of a particular entity by way of an agreement, by way of an understanding, or by virtue of the practice. So if somebody can prove that you are in a position, you are able to control the voting rights, it's very much possible for you to do so. And there may be a situation where you are holding 10%, more than 10%, but the voting rights are controlled by some other fellow for the same 10%. In this example, both these party individuals will be deemed as a significant beneficial owners. It is not either or, it is both. So let's say I hold 15% indirect stake in a reporting company, and for the same 15%, there was an agreement or understanding between me and another entity, and that entity holds the voting rights based on which I'll have to vote, or they will vote as a proxy or whatever. I mean, not proxy particularly, but this example is more pertaining to who decides the voting rights. So they have the voting rights, though I have the ultimate shareholding. In such a situation, both myself as an individual and that individual who is having the voting rights, both of us will be deemed to be significant beneficial owners towards the same investment, but as in a different capacity. In I am in a capacity as a shareholder having indirect percent of more than 10%. I mean, indirect holding of more than 10%, and the other fellow is having indirect significant benefit. I mean, they're having significant beneficial interest through indirect voting rights in the reporting entity. So here, when I'm taking the confidence that you have understood that when I say indirect significant beneficial ownership, I'm talking about a layer already, right? I'm not talking about my direct investments in the company. I have cleared at the beginning, direct investments are completely outside the scope of significant beneficial ownership. When I say indirect holding in a reporting company, I'm not at all talking about the full direct holding. I'm only talking about a layer above that. So that's about this. Third, has a right to receive or participate in not less than 10% of the total distributable dividend or any other distribution in a financial year through indirect holdings alone or together with any direct holdings. So through my indirect holdings or together with any direct holdings, if I have any right to receive more than 10% of the distributable dividend. So now you may ask, like Prakul, see, once you have shares, obviously it means you are having a right over your dividend. It need not necessarily be so. I may have lesser shares, but I may have a right over dividends of more than so and so percentage, which is, differential voting rights can be there. And I may have different rights over a dividend through some arrangement with other shareholders as well. So I'm not going into giving you a complete idea, trying to give you more practical examples on this because there's a lot to cover. But the idea is that once there is a dividend which is distributable and of which you have more, right to receive of more than 10% of that, then you will become, and I'm talking about an indirect right, like right through indirect holdings or direct holdings. But direct holdings will come secondary. It's always through indirect holdings if you're able to do it, clubbed with direct holdings. If you're having more than 10% of it, then it means you will have a disclosure. You will come within the ambit of definition of significant beneficial owner. And finally, such an individual has right to exercise or actually exercises, this we've already seen above, significant influence or control. And this last wording is of utmost importance in any manner other than through direct holdings. Now, this sets the complete context which I was trying to break my head and explain from the beginning, right? So, which is other than direct holding. So, other than me having a direct holding, if I have any right to exercise significant interest, or if I'm actually exercising significant influence, or if I'm actually exercising significant influence, or if I have any right to control, or if I'm actually exercising control in such a situation, this will come within the ambit, or the individual will come within the definition of significant beneficial owner. But the rule 2H has given various explanations which are quite interesting. Let's try to understand that. Now, in a situation where an individual does not hold any right or entitlement indirectly under either of these subclauses 1, 2, and 3, then they shall not be treated as a significant beneficial owner, which is quite clear. Next, an individual shall be considered to hold a right or entitlement directly in the reporting company. Right now, what is that wording? If you see here, the at the beginning of this definition on or the second bullet point I would like want you to focus on, which starts with acting alone or together. So over there in the second line, you can see that possesses one or more of the following rights or entitlements in such reporting company. Now, what is this right or entitlement? How do we determine that? Is something which this explanation is offering. It says an individual shall be considered to hold a right or entitlement directly in the reporting company if he satisfies any of the following criteria. One, shares in the reporting company representing such entitlement are held in the name of the individual. So if it is in your name, it becomes a direct holding. It will not come under indirect holding, and therefore it cannot be coming within the ambit of significant beneficial ownership. Second, where the individual holds or acquires a beneficial interest in the share of the reporting company under section 89(2). This is what something I was explaining at the beginning of my presentation. Under section 89(2), if I disclose my beneficial interest in the share of the reporting company, then, and I've also made such declaration in MGT5 with the company, and the company filed with MGT6 and all. So though I'm not a registered member in the company, since I have a beneficial interest in the company, even that will be considered as a direct investment. It is a direct investment in the company. It's not indirectly. So for this direct investment, there is no question of significant beneficial ownership and all. You just have to, comply with section 89, which is good enough. But if you have a further layer through which you are actually accessing this more than 10% of interest indirectly, that's when you will come within the ambit of significant beneficial ownership. Now, the other explanations, depending upon the type of member of the reporting company. So as I said, right, like if I take you back to this example, if F Limited is our reporting company, which we are focusing on, in F Limited, there is a shareholder D Limited, and there is other shareholders of up to 2%, 20%. But what is the category of this member of F Limited? D Limited is a company. So depending upon the type of this member, the criteria which decides my involvement as a significant beneficial owner will come. Like for example, see here, member of the reporting company. Now, if I satisfy any of the following criteria, I will have I will be considered to hold a right or entitlement indirectly. One, body corporate or other than LLP and the individual. So whether incorporated or registered in India or abroad, where they hold majority stake in that member or holds majority stake in the ultimate holding company of that member. So in this majority stake is obviously 50%. So if I am able to hold more than 50%, then I have a right or entitlement indirectly in the reporting company by default. That's what this is trying to explain. Similarly, if there is a HUF, which is a member, right, and you are a karta of that HUF, then you will be a significant beneficial owner of this company by virtue of you being the karta of HUF. Next, partnership entity. Now, in a partnership entity, either if you are a partner or you hold majority stake in the body corporate, which is a partner of the partnership entity. Let's say there is a partnership firm in which a company is a partner, and you are holding majority stake in such company. Then by virtue of that, you will have an indirect right or entitlement indirectly in the reporting company, because the member is a partnership entity, and in the partnership entity, you are either a partner or you are a member of a corporate partner in that entity. Similarly, you are holding a majority stake in the ultimate holding company of the body corporate, which is a partner of the partnership entity. So in these examples, it is considered that there is a right or entitlement indirectly in the reporting company. Similarly, next, where there is a trust. In case of a trust, if you are a trustee, if it is a discretionary or a charitable trust, or if you are a beneficiary, if it is a specific trust, only when you are a beneficiary, you will become a significant beneficial owner. Or if it is a revocable trust, then if you are an author or the settler of the trust, and only in such situation, you can be termed as a significant beneficial owner. Next, if it's a pooled investment vehicle. Now, pooled investment vehicle is quite tricky because, like collective investment schemes, it's a pooled investment vehicle. AIFs, they are pooled investment vehicles, but they are registered with SEBI. Now, for registration with SEBI, this entire rules do not apply at all. So, if it is an entity registered with SEBI, these rules do not apply. It is very clear. Now, but what other entities come under pooled investment vehicle is something which is left open. It is not clearly explained. But if it is based in a member state of Financial Action Task Force, like India is a member state of Financial Action Task Force, there are certain countries which are member states to it. In such a situation, the criteria to decide a right or entitlement in the reporting company will be whether you are a general partner or an investment manager or even a CEO of the company. So, of course, when the pooled vehicle is a body corporate or partnership entity, where you are a CEO of that entity. Now, see here, there is no question of, or rather, because as an investment manager or CEO, you may not even have shareholding in the pooled investment vehicle. You may not even have significant interest in the pooled investment vehicle. But by virtue of you being as investment manager, it is deemed that you are having a right or entitlement indirectly in the reporting company. To what percentage you have is a different scenario, but it is deemed that you have a indirect entitlement in the reporting company. But in a situation where such pooled investment vehicle is based out of any other jurisdiction apart from this, in such a case, all other criteria have to be looked into, as if looking by the type of the entity. If it's a company, then you'll go for company's criteria. If it is like body corporate, if it's a partnership firm, you'll go for a criteria of the partnership firm. So that way. But if it is a pooled investment vehicle based in a member state of FATFA, the Financial Action Task Force, in such a situation, this is the criteria which you have on the page is something which will be applicable. I'll just pause and take water. Just yeah. Now let me run you through the Ben forms, which will give you much better understanding of what is supposedly to be disclosed in a by the individual first, and subsequently what is supposedly to be disclosed by the company with the ROC. So first and foremost, form Ben 1. It is a form of declaration by the beneficial owner who holds or acquires significant beneficial ownership in shares. So that is the declaration file to be filed in form number Ben 1. So in Ben 1, first and foremost, it is a declaration provided to the reporting company. So I'll have to identify to which company I'm giving this for. Now, in our example, as I said, S1 has a significant beneficial interest. Let's assume S1 is filing this, and they have significant interest in C, D, E, and F separately, right? So they have to, like, as S1 is an individual, the individual has to file separate Ben 1s or disclose separate Ben 1s to all these companies separately, because it is addressed specifically to a particular company. So all your significant beneficial interest cannot be provided in one form. You will have to have different forms with different companies. In a single company, what interest you have is something which will be disclosed in PEN 1. That is the rule position. Now in this, first and foremost question will be, what is the purpose of filing the form? Are you declaring the significant beneficial ownership, or are you declaring or providing for or notifying any change in the significant beneficial ownership which you have already disclosed, right? So when you are disclosing a change, then there is an ID which is already generated at the time you are first filing for a disclosure. And this ID is generated by virtue of we filing, the reporting company filing the disclosure through Ben 2 with the ROC, as ID will be generated. Now, this is the purpose. Now, for the first purpose, so I mean, this rules have come long back, so I'm not talking about the initial disclosure, but subsequently, now, whenever you actually acquire such significant beneficial ownership, within 30 days thereof, you have got an obligation to file the declaration under Section 90 with the with the company. In an event you fail to do that, for every delay, there is a penalty of 1 lakh rupee, plus per every day, there is a fine of 500 or 1,000 rupees per day. These figures I'll just confirm. I'll just show you the relevant section. But ultimately, there are dual provisions. One, a penalty is also there, and a fine is also there, which can be levied by the ROC or the RD whenever they are doing this inspection and they find that something is missing. This can be levied not on the reporting company. This will be leviable on the significant beneficial owner, the individual. Now, so first, let's say we are declaring the significant beneficial ownership. Then comes the second details where we'll have to provide for the particulars of such significant beneficial interest, wherein we will provide the name, of that entity. Then secondly, we will provide, name of the beneficial owner, that is the individual. Then secondly, we will provide the address and email ID. So the address and email ID has to be provided, again, the same details. Then the date of birth, other details, occupation, nationality. And if it is a foreign national, then it is mandatory to provide for the passport number. Next, this point 3 is paramount important and also coming to E. So what does point 3 talk about? Point 3 talks about nature of indirect holding. So nature of indirect holding or exercise of right in the reporting company through member of the reporting company. Now, what is the nature of indirect holding is something which is being discussed in this clause. Now, in this, what it says is, firstly, type of member. Now, what kind of member is the entity? Is it a company? Is it an LLP? Is it any other body corporate? Is it an HUF, partnership firm, discretionary trust, charitable trust, specific trust, revocable trust, or pooled investment vehicle, or an entity controlled by a pooled investment vehicle is something which we have to opt. Now, all this we have seen in our deck, right? So we have seen if the member is a body corporate, HUF, partnership entity, trust, pooled investment vehicle. So all of this is something which will come in the criteria. Right. So this is what is the criteria. So all of this would come, any of this might come. So you will have to opt which is this. Now, in our example, all of these are entities, right? So we will go, all of these are companies. So we will opt type of member as company, right? So type of member will be company. Second, SIN or LLP identification number or any other registration number allotted by the regulator established under the Act. So that will again be another number. Then name of the member. So who is that member through which or through whom you are having the significant beneficial ownership? And this member is the member on the books of the reporting company. Now, in our example, on the books of the reporting company, D Limited is the member, right? So I hold, even though as an individual S1, I have holding in A has in B has in D, and D has in F, because of which I have the ultimate significant beneficial ownership. But ultimately, as S1, I will be disclosing the name of D here in the form, because the member has to be a member on the register of members of the reporting company, irrespective of whether their direct holding is in any other entity, right? So this is very important. I'll repeat this. First and foremost, it says nature of indirect holding through member of the reporting company. It need not necessarily be a situation where you have certain shareholding in such member. It is not required. What is required is whether such member is instrumental in you becoming a significant beneficial owner. In this example, S1 does not have any shareholding in D, but S1 does have significant beneficial interest in F. But that is possible only through D, because D is the member in F Limited. So S1 discloses. So in D directly, S1 does not have any shareholding. But ultimately, the member in F Limited is only D Limited. So here, when they ask name of the member, you should not get confused. You need not provide all these details. You only have to provide one detail as to this member. Who is the member on the register of members of the reporting company? That will be the decision factor. Okay. Then that member's address and details comes in the next step. And then the next step, the nature of indirect holding, this is where you will have to provide a percentage. Now, how are you holding this? How did you become a significant beneficial owner? Is it by virtue of shares? Is it by virtue of voting rights? Or is it by virtue of rights on dividend? Or is it by virtue of accessing of control? Is it by virtue of access of significant influence? All these 5 criteria are provided here. And when it comes to virtue of shares, voting rights, and dividend, you are supposed to provide a percentage as well. So over here, we'll take a simple example again. What percentage of significant beneficial interest does S1 have over F? Is straightforward 65% of 80, which is coming to 52. Right? So 52% is what we will provide here, and we will click a tick on by virtue of shares. Now remember, this is a disclosure made by the individual to the reporting company. So here the individual can either fill this manually or electronically, either of it is fine. Now it will be filled, this will be ticked, and by virtue of shares, the indirect holding of 52%, which is excess of 10. Next, status of significant beneficial owner in the member of the reporting company, right? So in the member of the reporting company, what is the status of the significant beneficial owner, right? So we have to choose anyone. So over here, it says what's the status of significant beneficial owner. The member is either it's an individual in case of company or other body corporate, partner in case of partnership firm or LLP. So if suppose the member is a partnership firm, are you a partner in that? Or if it's an LLP also, are you a partner in that? Is that how you have gained the significant beneficial ownership? And HUF, are you the Karta? Is that how you are claiming the significant beneficial ownership? And if it's a trust, are you a trustee? If it is a specific trust, are you the beneficiary? If it's a revocable trust, are you the author or settler? And if it is a pooled investment vehicle, are you a general partner, investment manager, or the CEO? Now, the same aspects we have seen on the presentation just before we have come down to Ben 2. That's the reason why I covered all of it in the presentation. So, in this scenario, if it is a company or a body corporate, it does not use the word member. It just uses the word individual. So in our example, I will choose individual, right? So in the member of the reporting company, I am an individual. I'm not the member of that reporting company, right? So that's about it. And then, of course, if you take any other example, let's say it's a partnership firm, LLP, as I said, maybe in another session, I can give you various scenarios in which these answers will change, right? Now, as I move forward, next question is, in case the member is a partnership firm or LLP, specify whether the significant beneficial owner, again, this we have seen, right? This we have again seen on the presentation. Let me just show you just so that you understand this better. So if it is a partnership entity, right, over there, again, we have 3 scenarios. It is a partner, or it holds majority stake in the body corporate, which is a partner, or holds majority stake in the ultimate holding company of the body corporate, which is a partner. Same questions come here as well. It says, in case the member is a partnership firm or LLP, the beneficial owner, significant beneficial owner, is he a partner? Is she a partner? Or does she hold majority stake in the body corporate and partner? So let's say it's a partnership firm in which there is a body corporate partner. Does this significant beneficial owner holder hold majority stake in the body corporate partner, or holds majority stake in the ultimate holding company of the body corporate partner? So do they hold do they hold majority stake, having majority stake in the ultimate holding company of the body corporate partner? In either of this, we'll have to disclose here. Then, in case the member is a company or any other body corporate, specify whether significant beneficial owner holds. Now, is that significant beneficial holder holding majority stake in such company, that is in such member, or majority stake in the ultimate holding company of such company or body corporate? Either of it is something which we'll have to tick. Next, whether significant beneficial, again, here, what they're trying to explain here is it that you are claiming it as a stakeholder in this company, which is a member of reporting company, or in the ultimate holding company in which you have a stake, through which you are claiming this route and claiming and filing this form. And then whether significant beneficial owner has any direct holding or right in the reporting company. Now, this is a second question, or rather a subsequent idea to understand if you also have a direct holding in the company, in the reporting company. So from A to H, the focus is all on the indirect investment and in the member of the reporting company. While I is, are you a member of the reporting company? Or rather, do you have a direct holding or right or entitlement in the reporting company? If your answer is yes, you'll have to provide how do you have that direct holding? Are you a holder of the shares? Do you have voting rights? Do you have a right over distributable dividend, or you can access control over the reporting entity, or can you exercise significant influence over the reporting entity, right? So the entire definition of significant beneficial owner, once it is cut into a form of disclosure, is what is BEN 1, right? And BEN 2 is something which is an extension of it, because BEN 2 essentially provides for all, BEN 2 provides for this the same details the BEN 2 will provide for it to be disclosed with the ROC. So if you observe BEN 2, yeah. So in BEN 2, again, once you fill in that, this is all fine. So there are three purposes, right? Purpose is first for declaration of significant beneficial ownership. And once you are declaring for significant beneficial ownership, if you are also providing declaration on behalf of your holding company, I have told you this, right? These rules will not apply in certain situations. This is one such situation where you are also providing declaration for your holding reporting company. Then that company's details also have to be provided here. The SIN has to be provided, in which situation the holding company need not actually file a separate disclosure, right? Then I'll have to provide for how many number of members am I using this form for. So even though I may get significant beneficial ownership disclosures in BEN 1, let's say I've got it from 4 different individuals, but I can still file all of it in one single form. Now, that one, there is a maximum cap on this. Of course, it's a practical thing. You can only file this form for a maximum of 9 significant beneficial owners. If the number of significant beneficial owners is exceeding 9, technically there is a reason why they kept a cap of 9. That is, if there are more than 9 people who are exercising more than 10% of control stake in the company, then it's obviously 90% is done, right? So the other fellow will definitely have less than 10% indirect stake in the company. But it need not necessarily be so, because if you are having that indirect interest or right or entitlement in the reporting company through control or through significant interest, in such a situation, there is definitely a chance it can exceed 9. That's my personal opinion. But ultimately, there's a cap on 9. Then as I move forward, what does it ask? It asks about the details of the member. So again, what is that? What does it mean? It explains here. Manner in which significant beneficial interest is being held or exercised either indirectly or together with any direct holding or right. It's the same situation, right? So whatever the beneficial owner has disclosed, the same will be disclosed in this form. If it is by virtue of shares, you click on it and provide a percentage. If it is by virtue of voting rights, click on it and provide a percentage. That's how it works. And next, what is the type of the member? Who is this member? Is it a company, foreign company, or it's any other body corporate, LLP, HUF, partnership firm? Let's say it's a partnership firm. Then it's I'll just click on the partnership firm. Or I can, if it is a company, I would have provided for the details and then pre-fill this. If it's a partnership firm, I would not be in a position to do that. Then all the details of the member will be auto-populated, or we'll have to fill it. And then this date of entry of name in the register under section 88. So this is a clear indication for you to understand. See here, it is the company, right? Since we are the company, we are looking into this. Now, if I show you this, in this BEN 1, this detail of entering the name in the register of members is not present. See, if you can observe, it is not there, right? It is only there in BEN 2. Because as a company, when this member is entered as when this member has become a member of your company, or when this member is entered in the register of members under section 88, that is very clearly maintained in your register of members. That's why this obligation is kept on the company to provide for. Right? Again, I repeat, this is not the details of the individual. This is a detail of the member through which you are exercising this indirect right or entitlement over the reporting company. And then the status of the significant beneficial owner. If it is a direct company or LLP, it's an individual. We just discussed this in Ben 1. So whatever is clicked there in Ben 1 or selected in Ben 1, disclosed in the Ben 1, we will use the same here. Then whether the significant beneficial owner, that is the individual, has majority stake in the reporting company's member. If yes, or in the ultimate holding, it will be either of it. Then in such an event, if it is in the member of the reporting company, there is no need of giving any further details because the members' details have already come. If it is, by virtue of an ultimate holding company, if you are able to have that majority stake there, then you'll have to provide the details of that ultimate holding company. Then, now in a situation, this is for an individual, right? So it says majority stake. Now, if it is a partner or holds, right? So this point, if you see, this gets disabled because you are providing for a disclosure in a company. Now, let us take a situation where let's take a situation, the type of member is partnership firm. Okay. In such a situation, and the status of member is partner. In such a situation, this gets wiped off. Okay. What will come is whether the individual is a partner or holding majority stake in the body corporate partner or in the ultimate holding company of the body corporate partner. So this way, depending upon the type of person you select, the option which you'll have to fill will vary. And this is quite straightforward. It's not something which I'm trying to highlight, but it's something straightforward. Depending upon Ben 1 and Ben 2, depending upon the type of person, these disclosures will vary. And then particulars of the significant beneficial owner. So what is the ID of the significant beneficial owner? And this ID, of course, it will be generated upon, and subsequently you'll have to provide the details of this beneficial owner, and you'll have to generate all of this and then provide for ultimately when did you receive the declaration. So this will decide within what day, because once we receive the declaration, within 30 days, we'll have to file it with the ROC. So this time period will decide how we will have to, by when we'll have to file this with the ROC. If not, additional fees also applicable on the company. And all other details like when did they acquire significant beneficial interest and what are their, these personal details of them. And if they're, having a PAN in India, then their PAN details and all will be provided here. And so these are the details. And suppose if you're already a beneficial owner and you are not providing declarations, but you are providing a change in the significant beneficial ownership. Okay. Okay. In such a situation, you just have to provide for what is that change. Let's say this I will remove. Yeah. So once I opt for a change in significant beneficial ownership, so there I will provide, there, if you see, we already have the significant beneficial owner ID, we will pre-fill that. And also we will provide for, all the essential, once we provide the details of the SIN, the other details will automatically come in and we'll have to provide what is it that change which we had, right? So that will again be disclosed. And if you see, the form remains the same. There is absolutely no change in the form. But the only difference is, at the back end for the MCA to understand that, okay, earlier there was a fresh disclosure with the fresh ID. And second, when you go forward, the same ID, you are providing for a change in the disclosure. So in the change also, you will not show what was before, what was after. You're only showing what is after. The system in the back end will see the difference that before they disclosed 24%, now it is disclosing 34%. So in the back end, they understand that there's a hike of 10% of interest. So that's how it works in the back end. So this is what is the total form Ben 2, and it will be certified by a practicing professional. And it is what the practicing professional essentially certifies, particularly me and you, we kind of professionals. What are we certifying in this is that we have verified the above particulars, including attachments from the original records maintained by the company. So here they use the word verified the particulars. So now, though the company is depending upon Ben 1 alone and filing this form, but as a practicing professional, when we look into this, we, as a matter of practice, should always insist for backend documents to justify that whatever is disclosed by the company in each of this is valid and is backed by certain documentation. Even in Ben 1, when a disclosure comes, it should not blindly be believed by a company, right? Even though the law doesn't say so. The law only says once it comes, you file Ben 2 with the company, with the ROC, which is good. But ultimately, there has to be some reasoning and justification as to how that holding is there. So that exercise has to be done. Though it is not explicitly told to be done, it has to be done. And particularly from the professional's point of view, we should be thoroughly clear that this is and the details whatever are entered are backed by certain evidentiary documents. How do you interpret it is something you can defend at any point in time. See, today you may interpret, like for example, the language used here, if you see, it says holds major, like let me take the case, let's take the type of the case as a company, right? Now in a company, it says whether the individual is a partner of the member holds. Okay, now in the company, let me take the status of the SBO as individual. Now it asks whether the individual has majority stake in the member of the reporting company or ultimate holding company of the member of the reporting company. Now this majority stake, right? What is a majority stake? Let's quickly look into it. Yeah. So if you see, the majority stake means holding more than one half of the equity in the body corporate, holding more than one half of the voting rights, and having the right to receive or participate in more than one half of the distributable dividend or any other distribution. Now, going back to the form, where whether individual has majority stake in the member of the reporting company or ultimate holding company of the member of the reporting company. What if you don't have more than 50%, right? Let's say you are having 49% of the stake, while your member company is having 100% in the reporting company. Now, indirectly, you're adding more than 10%. That is very clear, right? So, does that mean this entire thing does not apply? Obviously, it will apply, right? So, the question here is very challenging here. So, this is kind of a thing which we need to understand. That is an interpretation issue, and that is something which we can justify through a note to the ROC or whatever. But ultimately, getting back again, I'm not, as I told, I'm just trying to give a legal position today. And as I said, in a subsequent session, probably we can deliberate on various sub issues which can come, whether it is correct, not correct, or something which can be discussed in a different session altogether, exclusively on cases and I know as illustrations, and try to understand what complexities are there in these interpretations of these rules. But here I'm only trying to provide you with the position of law. So ultimate idea here is that as a professional, when we are certifying this kind of a form, we need to make sure that for every entry made, there is essential backup provided for, and we are verifying it before we are certifying this. That's one kind of challenge we have as a professional too. One is advisory. Second is to certify this to say that this is correct, right? Because it says particulars, right? It says the verified the above particulars, including the attachments from the original records. So when I use the word particulars, it means everything which is entered here, right? So we'll have to be definitely thoroughly invested and understandable on what happens to this scenario, right? So now let me take you back through the rules. Now, so this is with respect. I mean, we have seen. Firstly, you have understood who is a significant beneficial owner. Then we have seen that there's a requirement of filing Ben 1 by a significant beneficial owner to the reporting company. Then we have also observed that there is a need for the reporting company to file Ben 2 with the ROC. Now, what will happen if this individual fails to file Ben 1 with the reporting company? That is something let us quickly run by through our sections, right? Yeah. So subsection 4A Now, this is an interesting subsection I would request all of you to focus on. So 4A says, every company shall take necessary steps to identify an individual who is a significant beneficial owner in relation to the company. So, necessary steps. So, a company has been tasked with certain responsibility to identify such an individual who is a significant beneficial owner in relation to the company and require him to comply with the provisions of the section. So, now this is something which is interesting. And this is the whole reason why there has been an advisory recently provided by the MCA to the company's directors and everybody to make sure that they are in strict compliance of these provisions. Now, if a responsibility is cast on the company to identify, let us say in our example, F Limited has identified that S1 is the person who has to do the disclosure. Now, and F Limited wanted to approach S1, but S1 denies to provide any such disclosure. Now, till what extent is F Limited liable? So, can I go and make, force him or use coercion to get the S1 sign on the Ben1? Obviously not. So what is the course of action which I have to do as a company is what is provided under subsection 5 and subsection 6. So what it says is a company shall give notice in the prescribed form, which is Ben 4, to any person whom the company knows or has reasonable cause to believe to be a significant beneficial owner of the company. Right? And to be having knowledge of the identity of a significant beneficial owner or another person likely to have such knowledge, or to have been a significant beneficial owner of the company at any time during the 3 years immediately preceding the date on which the notice is issued. So here, upon apprehension or upon my clarity that it is a significant, I have a reason to believe that they are significant beneficial owners, or have a reason to believe that there is a person who has the knowledge of the identity of the significant beneficial owner. Like, for example, I went till A. Now I know A might have some knowledge on who is the individual holding in A, and I could not find those details anywhere from A. And even when I'm asking A for the details of shareholding, they're not disclosing. Then I can even send this notice to A LLC to say, boss, you are the person to whom I have a reasonable knowledge to believe that you have a knowledge to know who is a significant beneficial owner. Right? To have been to be having knowledge of the identity. So here ALLC has the knowledge of the identity of the significant beneficial owner or another person likely to have such knowledge. So either ALLC has that knowledge or ALLC knows somebody who has a knowledge of the ultimate significant beneficial owner, or to have been a significant beneficial owner of the company at any time during the 3 years immediately preceding the date on which notice is issued. So I have a cause to believe that in the last 3 years, at some time, this fellow might have been a significant beneficial owner and who has never disclosed this. And who is not registered as a significant beneficial owner with the company as required under this section. So, having known all this, but that fellow has never registered with it. Obviously, this is an obvious thing, right? So, someone who is not a significant beneficial owner. In such a situation, a company shall give notice, and this notice shall be provided in form Ben 4. Right? Now, let us have a quick look at this notice. What does this notice comprise of? It's a simple notice which is sent by post or email to the address of such significant beneficial owner or any other person as identified under 90 subsection 5, where it only says, a company has a cause to believe that ABCD is the same thing again, based upon our interpretation. Here you are a significant beneficial owner, or you have the knowledge of who is the significant beneficial owner, or you being a member holding not less than 10% or dividend or distribution or any distribution in the company, or you have been a significant beneficial owner of the company during the 3 years immediately preceding the date. In either of the situations, I will send this notice. You are accordingly advised to give the following information. What is your beneficial ownership, or no, what are the terms through which you have gained this beneficial ownership, etc. Again, straightforward. And also the reason for not filing declaration. Why didn't you file the declaration till date, or any other information which will help us evaluate this matter further. So this way, we will have to provide, we'll have to seek certain information through our notice. And we will have to provide for the draft Ben1 format for the compliance. And we will have to provide that it has to be submitted not later than 30 days, failing which it shall proceed in accordance with the provisions of the Act. And this, I understand we have another 15 minutes, but this further action which the company can take is something which is very important. Let us try to spend some more time on that. Okay. Yeah. So now after subsection 5, let's run to subsection 6. It says, the information required by the notice shall be provided within a period not exceeding 30 days. We have seen that in Ben 4 also. Now, in an event where the person fails to give that information or the given information is not satisfactory, that is something which is vital. So let's say I have identified S1 in our example. So in our example, I have identified S1 as the one who is supposed to have submitted the form for significant beneficial ownership. Ben 1 particularly, and they fail to. Then I have sent a notice in Ben 4. Even then they fail to respond or the response is not satisfactory. Then as a company, is my duty, does my duty end there? Can I be quiet? No. The law says in such a situation, you will have to apply. And it says the company shall. It is not a discretion on the company. It says the company shall apply to the tribunal, which is NCLT, within a period of 15 days of the expiry of the period provided under Ben 4 in the notice. Right? So after 30 days, another 15 days, which is 45 days in total. So after 30 days, I give 30 days time for the person to provide the disclosure. I will again wait, I will, within 15 days, I'll have to make an application to the NCLT for an order. So what will be my prayer? My prayer will be to direct that the shares in the question be subject to restrictions with regard to transfer of interest, suspension of all rights attached to the shares, and such other matters as may be prescribed. So I will have to essentially make an application to the tribunal to say, boss, please pass an order to restrict their rights to transfer the interest of the member. So I would have identified a particular member through whom this fellow would have become a significant beneficial owner. So I will identify that particular member. And to that particular member, I will be providing, or I will be seeking these prayers to say that such particular member, there should be restriction on the transfer of interest, suspension of all rights attached to the shares held by that respective member. And once we make that application, then the NCLT, after giving the opportunity, makes an order restricting the rights. And that has to happen within a period of 60 days of receipt of the application. So there's a limitation for the NCLT to pass orders within 60 days, right? Now, of course, if there is, let's say after that, if the party comes forward, they can obviously file for a IA before, an application to the NCLT to relax the restrictions and, by way of any justification the limitation is of 1 year. Within 1 year, at any time, you can file an application to relax that applicability or lifting of the applicability in an event where you suppose I have filed it, the NCLT ordered for restriction, but subsequently I got certain evidence through which I realized that this person is not a significant beneficial owner. In such a situation, as a company, I have a responsibility to inform this to the tribunal for lifting of the restriction, and that is also enabled under subsection 9. And in an event within 1 year limitation, no such application is filed. In such a situation, all such shares shall be transferred to IEPF authority. This is a very dangerous provision. So if you fail to make your significant beneficial ownership disclosure, if you ask me in one line, what can happen if a person fails to submit a form Ben 1 of significant beneficial ownership? Two things can happen. One, a penalty. Two, transfer of such shares to IEPF in the procedure which we have seen. So these are the two things which can happen if you fail to file your form Ben 1, or if our clients fail to file form Ben 1. Now, as we move forward, subsection 10, if a person fails to make, so this is a penal thing. If you fail to make a declaration as required under subsection 1, then such a person shall be liable to a penalty of 50,000 rupees. So it's a penalty of one-time penalty of 50,000. Sorry, I think I said 1 lakh. It's 50,000 rupees. And in case of continuing failure, with a further penalty of 1,000 rupees for each day after the first day during which such failure continues, subject to a maximum of 2 lakh rupees. So the total penalty in case of continuing failure and all that max would be to 2,50,000 rupees is what is something which they are levying on. And similarly, if the company fails to maintain the register or file information under in Ben 2, so register. Again, this register company has to maintain a register of significant beneficial owners, and such register shall be maintained in form Ben 3. Okay, so Ben 1 is relationship disclosure, the significant beneficial ownership disclosure by the individual to the reporting company. Ben 2 is the disclosure by the reporting company with the ROC. Ben 3 is the form or register which we have to maintain in by the company, register of significant beneficial owners. And Ben 4 is the notice, when a notice provided by the company to an individual or any other person whom we apprehend to be a significant beneficial owner. So these are the 4 forms prescribed under significant beneficial ownership rules. So if the company fails to maintain register in Ben 3 or file the information with ROC in Ben 2, or does not take steps by sending notices even when the company is aware of, or company has all reasonable means to be aware of who can be a significant beneficial owner, and still the company does not take any step to approach such person by sending a notice under Ben 4, in such situations, the company shall be liable to a penalty of 1 lakh rupees. And if that continues, if it's a continuing failure, for every day, a penalty of 500 rupees, and it is subject to a maximum of 5 lakh rupees. And it does not end there. Even the officer of the company who is in default shall be able to pay a penalty of 25,000 rupees, and in case of continuous failure, a penalty of 200 rupees per day, and it is subject to a maximum of 1 lakh rupees. Now, these things can come up through inspection by the ROC. So these are not like, when you file for Ben 2, you will go and voluntarily make the payment. It's not like that. When ROC does any inspection on the company, or when ROC seeks certain information, and ROC through its investigation and inspection understands that there is some failure, then ROC has every right to levy this penalty on the company. And the recent the advisory which MCA has provided for all the companies and all the clients, I think that is this webinar per se is an outcome of it. And as 3PM ma'am was highlighting, even MCA wants to conduct more such webinars to sensitize us. That shows a very clear indication that we are not that far away from inspections and all happening from ROC on these kind of companies. So we'll have to be furthermore careful to see if there is any such kind of a chain which we can establish. If yes, then it is better. Even today, it is better late than never to immediately file these forms and try to see to it that if required to go and get this compounded also for all the penalties. So this is the position with respect to non-disclosure of forms in Ben 1. And if we have to go back to the rules and just quickly wrap, before I end up the session, I know there's just 10 minutes. I'll just want to highlight a couple of interesting, important rules, particularly this tribunal thing. Yeah, we can, as I said, this tribunal thing is fine. We can end there. There is no need of further discussion on it. The register is also fine. Yeah, 1 second. Yeah, there is a rule 8, which is most important. I wanted to capture this before I end the session. So rule 8 is the non-applicability of these rules. So there can be a situation where this may not even be applicable to our clients, right? So we need to understand what is that which may or may not be applicable to a particular client, right? So first and foremost, it is not applicable to IEPF. So if IEPF is holding significant beneficial ownership in the reporting company, in such a situation, you need not dig back to understand who is individual. Obviously not, right? It's an authority. So it's a government authority particularly. So there is no point of going back. So IEPF authority, when it's holding shares in the reporting entity, so you need not go back to understand in the IEPF, it's a standard straightforward exemption from the applicability of these rules. Next, it's holding reporting company. Now, this exception I have explained you on a couple of scenarios. And I've also given you an example here that D Limited is the holding reporting company of F Limited. And for D Limited per se, this will not apply. It says these rules shall not apply. The entire rule shall not apply. However, it says the details of such holding reporting company shall be reported in form Ben 2. And this also we have seen. We have seen here this highlighted portion for declaration of holding reported company, right? So this is what I'm referring to. You will have to disclose this in an event where you are trying to claim that exemption for the holding company, right? So when you are claiming exemption for the holding company, then you will have to provide the details of the holding company in form Ben 2. So this is one other exception where the rules are not applicable if the extent of shares in the reporting company is held by its holding reporting company. Third, if it is held by a central government, state government, or a local authority. So where the shares, to the extent of the shares held by a central government, state government, or local authority, or where there is a reporting company and the reporting company in itself is controlled by a central government or state government, or partly by central and state, or by a body it's a body corporate or an entity. So it's just again a blanket exemption. So if the reporting company is controlled by a central government or state government, or partly by central and state, like like a metro project in state of Telangana, but it's if there is still a possibility, because it has to be controlled. The control is most important for us to understand here. And it says partly by central government and partly by one or more state government. So if it's a joint project by central government and state also, then it comes here. But like, for example, I was referring to the project, the metro project of Telangana. So there we have a private investment of L&T as well, right? So to the extent of that holding, this rules will definitely apply. So that's why you need to understand this usage, that shall not be made applicable to the extent the share is held by. That is most important. Right. And then, of course, this. And coming to the next non-applicability is with respect to investment vehicles registered with SEBI. So SEBI registered investment vehicles like mutual funds, AIFs, alternate investment funds, REIFs, real estate investment trust, REITs, real estate investment trusts, IIFs, infrastructure investment trusts. All of it uses the word such as. So these cannot, for these entities, to the extent of such holdings, like for any reporting company, if you have a mutual fund or an AIF, you need not dig back to understand who is a significant beneficial owner, who is the individual owner who is holding all this. That's not required, because they're registered with SEBI and they're already under the complete control and understanding of what's happening. And finally, investment vehicles regulated by RBI or IRDI, that is Insurance Regulatory Development Authority of India, or Pension Fund Regulatory and Development Authority. So when these, when they are investing or they are investing in shares of a particular company through their trust. So let's say they form a trust, and in the trust they pull in the money, and the trust is investing in other companies. All of this is happening through a particular framework. There is a law for it. It's regulated by RBI, IRDI, or the Pension Fund Authority, etc. So in such cases, we need not again dig back to understand who are the significant beneficial owners. These rules shall not apply. So the rules shall not apply only in these 6 situations. Apart from this, for every other company, the rule shall equally apply. And before I conclude this presentation, so I just want to say one thing, that the whole point of this, I already told at the beginning, the whole concept of significant beneficial interest ownership is not meant to prohibit having individuals as significant beneficial owners. It is only meant to be transparent when you are a significant beneficial owner. So there is no point to be afraid to disclose. Obviously, yes, there is. The whole reason is to curtail shell companies from expanding it. Like we know, parallelly, there is a restriction on number of layers of subsidiary companies not exceeding 2. And this is one other restriction. So this way, what essentially is happening is we understand who is the one who is behind, the individual, the natural person who is behind all of this, right? So to establish that, this concept of significant beneficial ownership has arose globally, and it's a global phenomenon. It's not just in India. And since in India we have a hell lot of companies, the applicability of it is still at a very nascent stage, I would say. Though the rules have come long back, it is still taking time for all companies to implement this, and even for ROCs to understand whether a company is implementing or not. It is definitely difficult, and you cannot even make it part of an audit. Like suppose it is made part of a audit, let's say secretarial audit. What best can a secretarial auditor do is to see if at all the company. So the secretarial auditor will ask the company, did you receive a Ben 1? Yes. Then did you file Ben 2? That's where the audit stops. So in case ROC wants a serious applicability of a beneficial ownership thing, I feel obviously it is an additional burden on the company, but in an event they want to do, maybe a one-time audit on all companies by individual professionals may be advised by the MCA, so that such an audit will be extensively done at the cost of the company, and the output of it will be filed with the ROC so that they understand what is happening. But it all comes at a cost to the company. Even this filings and doing the back end, digging back into who are the owners and all that is at the cost of the company itself. So it is kind of providing the MCA with all the inputs which are required. So I think probably, I felt at the end of session, I felt this is one suggestion we can think of. So depends upon the case, that if MCA wants to effectively implement it, maybe a one-time audit kind of a situation may be introduced, by which set of, like professionals like chartered accountants, practicing chartered accountants, cost accountants, or company secretaries can be authorized to conduct such audits and provide a detailed investigation reports as to what documents they have referred to come to a conclusion that there are no significant beneficial owners, or to a conclusion that there are and they have already filed or they are yet to file. So what happens with this is there would be a there would be a sincere effort which will be, or kind of a sense which will be felt by all the companies to start complying with this. So with this, I conclude my presentation on significant beneficial owners. And as I said, if I get an opportunity, I would be more than happy to take you through various situations when what we faced from our own practical experience, as to in certain illustrations I can give to explain how it was difficult for us to either to make a decision as to whether it is a significant beneficial owner, she or he is a beneficial owner or not. There are various situations, including inter-se family arrangements. Like, for example, a father and son together are holding more than a particular percentage. But if you boil down, the father and son can be completely independent people, separated from each other, having their own investments and doing things, or they may be dependent, like the father is dependent on the son. So how do we prove it? Do we take their holding as one holding, as through one or more persons, and show both of them as significant beneficial owners? Or do we show them separately and treat them separately and go with their individual holdings? So these are things which we have to, deliberate on, and these things will have a huge bearing on understanding whether these will give us some additional thoughts from in interpreting these provisions in a sense which is more practical and which meets the spirit of the law over the letter. So with this, I conclude, and I stop my presentation here. I'll hand it over to Seema. Thank you, Seema.
Thank you so much, sir.
Yeah.
Thank you for giving such a detailed presentation and a clarity on the significant beneficial ownership regulations, which are a step towards a more transparent and accountable corporate environment.
Yeah.
And I would like to also thank all the participants for their active engagement during the session. On behalf of the Corporate Laws and Corporate Governance Committee of ICI, I would like to thank Mr. Prakul for making such an excellent presentation and making the session a fulfilling one. Thank you so much, and we look forward for many more deliberations from your side, sir. Thank you so much.
Thank you so much. Thanks.
Thank you.
Thank you for the opportunity. Thanks.
Thank you.